Exam Scholar, Real Estate Edition.
Question 1. If a minority person is looking to purchase a home and the lender refuses to lend to them based on their creditworthiness, this is A. Legal, B. Racial profiling, C. An example of blockbusting, D. Illegal. Answer A. A lender is not required to lend to any person that does not meet the requirements of creditworthiness. Question 2. When a real estate developer obtains a loan for building a new housing tract and the lender gives part of the funds to the developer and agrees to release the rest of the funds as each home is built, this is called which type of financing? A. Earnest money, B. Fixed amount, C. Obligatory, D. Chronological release. Answer C. In this type of situation, this financing is called obligatory financing or also called fixed disbursement schedule. Question 3. A reconveyance deed is used in connection with A. A life estate sale, B. A trust deed sale, C. A valid transfer of ownership in any property, D. None of these. Answer B. A reconveyance deed is used in connection with a trust deed sale by a trustee to a trustor after a loan has been paid in full. Question 4. In order to form a valid contract, which is not necessary? A. Performance, B. Consideration, C. Offer, D. Acceptance. Answer A. Even though an offer has been placed, the offer accepted, and consideration put forth, there is no guarantee that either party will perform the obligations of the contract. Performance is not a necessary part of forming a contract. Question 5. In regards to contracts, if part of a contract is written and another part is printed, which part takes preference? A. The typed part, B. The written part, C. None. Contracts must be typed, D. They are both equal. Answer B. If part of a contract is written and another part is typed, the written part takes preference over printed parts. Question 6. If a contract is written and parts are incomplete or ambiguous, what type of agreement takes preference? A. An oral agreement, B. A new typed agreement, C. A new written agreement, D. None of these. Answer. In this case, if a contract is written or typed but is ambiguous or incomplete, an oral agreement then takes preference. This is true only if the original contract is ambiguous or incomplete. Question 7. If a person wishes to obtain a chattel mortgage, they would need to put up A. Personal property as collateral, B. Another property as collateral, C. Any type of property as collateral, D. None of these. Answer A. A chattel mortgage is a mortgage that is secured by personal property. Question 8. A real estate broker is typically considered A. An agent or fiduciary of the principal, B. An attorney in fact, C. To have the power of attorney, D. None of these. Answer A. A real estate broker is typically considered an agent or fiduciary of the principal. A broker does not have power of attorney unless the principal grants him/her that right. Question 9. If a broker notifies a seller, of whom the broker is working with by means of listing, of a prospective buyer, this creates what to entitle the broker to a commission. A. Procuring cause, B. Prior notice. C. Fiduciary relationship. D. Accelerated notice. Answer A. If a broker notifies a seller of the identity of a prospective buyer of a listed property of a client the broker is working with, this constitutes procuring cause. If the seller were to then go to the prospective buyer later without the broker's knowledge and make a deal, the broker would still get the commission due because the broker was the procurement source of the buyer. Question 10. The bulk sales law is included in A. The Habendum Clause. B. The Caveat Emptor Clause. C. The Uniform Commercial Code. D. The Governing Laws of Commerce. Answer C. The Uniform Commercial Code includes the bulk sales law. Bulk sales laws are intended to prevent business owners from defrauding or evading creditors by transferring all, or a substantial portion, of the assets of the business to another individual or entity. The law is also intended to avert the possibility of businesses selling their assets below fair market value in a sweetheart sale, in which the owner of the business manages to maintain a degree of control.
Exam Scholar, Real Estate Edition.